Welcome. Today, we're undertaking a very intensive examination of what has to be one of the most devastating institutional failures in recent legal history. We're talking about the Shirley McKie fingerprint scandal.
We are. And our goal today isn't just to sort of recount the timeline, it's to really explore the profound questions that come up when forensic science, something we see as a pillar of justice, is shown to be not just fallible, but completely and demonstrably wrong.
This is a case that really should be studied, I think, everywhere. It's a painful but very necessary look at institutional accountability.
It really is. When we talk about forensics, there's this perception of infallibility, a kind of scientific certainty that's almost impossible to challenge. This story is about the systematic breakdown of that very myth.
And it all begins with a truly tragic crime. That event then sets in motion this decade-long ordeal for Detective Constable McKie, whose life was, well, it was almost destroyed because she chose her integrity over complicity.
Yeah.
The source material we're working from gives us a really comprehensive look at how this all unfolded. It traces everything from that initial murder investigation back in 1997 all the way through the legal battles, the political fallout, and then right up to the findings of a major public inquiry.
And our mission here is to synthesize all of that complexity for you. We want to understand the exact moment the forensic error happened, analyze why the state fought so fiercely against admitting it, and really extract the crucial insights. What happens when the mechanisms of the state decide to protect their own reputation over the fundamental pursuit of truth?
Okay, so let's start right at the beginning. The foundation upon which this entire scandal was built. It all kicks off with a horrific discovery in Kilmarnock, Scotland. On January 8, 1997, the body of Marion Ross is found in her home. She had been stabbed multiple times, a truly brutal crime that demanded, an immediate and rigorous forensic investigation.
And pretty quickly, a primary suspect was identified, a man named David Asbury, who was a handyman and had done some work on the Ross house before.
So as you'd expect, the investigation immediately starts to rely very heavily on the Scottish Criminal Record Office, the SCRO, for fingerprint analysis. They need to link Asbury to the crime scene.
Right. This is standard procedure. And in any murder case, you need absolute clarity in that forensic link. It's everything.
So what was the specific fingerprint evidence that the SCRO claimed to have? The evidence that, ultimately secured Asbury's conviction in the first place?
Well, the SCRO examiners pointed to two critical pieces of evidence. First, they said they'd found a fingerprint on a tin box, and that box was inside Asbury's own home. They identified that print as belonging to the victim, Marion Ross.
Okay, so that's a direct link from the victim to the suspects.
A very strong link. And second, they identified a print on a Christmas gift tag that was found inside Ross's home. That print, they said, belonged to David Asbury.
Now, this is where a specific detail about the victim's life becomes absolutely critical to understanding the whole controversy that follows. The sources are clear that Marion Ross was known to hoard possessions.
Yes, and that fact is key. It's so important because it immediately complicates the weight of that second piece of evidence.
The gift tag.
The gift tag.
Yeah.
If Ross was a hoarder, that print from Asbury could plausibly have been left years earlier when he was just, legitimately working there. It puts that gift tag print into a category of evidence that's suggestive, sure, but it's not conclusive of him being there recently to commit a crime.
So if the print inside Ross's home was a bit ambiguous because of the hoarding, what piece of evidence really became the linchpin? The thing that held the entire case against Asbury together?
It had to be the other print, the one found on the tin box inside Asbury's home, which the SCRO examiners swore belonged to the victim, Marion Ross.
That's the one.
That provided the indispensable link. It places the victim's print directly in the possession of the accused. If that identification was solid, it was incredibly strong evidence for a conviction. And in fact, that ID became the very foundation for the guilty verdict.
And now, Detective Constable Shirley McKie enters the story. She was a police officer, born in August 1962, involved in the wider investigation, but she always maintained she was not part of the initial team that entered the crime scene.
And then, a few days after the body was found, on January 14, 1997, the SCRO staff alleged that they found her thumbprint. They said it was on the bathroom door frame of the murder scene. They found it while checking other unidentified prints from the house.
And this is the exact moment where a simple institutional error begins to fester, and it turns into a systemic crisis.
It is, because McKie was called to testify during David Asbury's murder trial. She's under oath, And she states unequivocally that she had never been inside the Ross home. Therefore, she could not possibly have left that print.
Her denial wasn't just a simple disagreement, was it? It was a direct challenge to the sort of professional infallibility of the entire Scottish forensic establishment.
Oh, absolutely. It changed the stakes completely. It created an immediate existential crisis for the SCRO.
Because if she's telling the truth...
Exactly. If Shirley McKie is telling the truth, which she insisted she was, it meant that the very same SCRO examiners who provided the core evidence for Asbury's conviction were capable of making a catastrophic error, a sworn error in identifying a print.
And you just can't have it both ways.
You can't.
Yeah.
You cannot have a justice system where you rely on the testimony of experts in one case, only to have those same experts proven demonstrably wrong on a closely related matter. It instantly threw the entire foundation of Asbury's guilty verdict into question.
So the institution had a choice.
A stark choice.
Ah.
Admit a terrible error or destroy the reputation of the officer who was pointing it out.
And we know which choice they made. The professional consequences for McKie were immediate, and they were brutal.
The institutional reaction was just so swift, and it was all about protecting the system. First, she was suspended. Then she was sacked from the police force.
And then it got even worse.
Much worse. In what is just a shocking move, she was arrested by Strathclyde police in March of 1998 and charged with perjury.
For lying under oath about not being in the house.
Yes. And that action, that decision to prosecute her, it suggests that the authorities thought the possibility of a police officer lying was somehow less damaging than admitting that their forensic experts were fundamentally mistaken in a murder case.
It's a choice to protect the image, the perceived integrity of forensic science, over the actual integrity of an individual officer's sworn testimony.
That initial decision to prosecute Shirley McKie for perjury is so crucial. It tells you everything about where the power structure's believed loyalty should lie.
With the SCRO's reputation.
And not with the individual telling the truth.
So the stage was now set for the pivotal moment in this whole narrative, Shirley McKie's trial for perjury.
And this wasn't just about her innocence anymore, was it?
Not at all. It became a proxy trial for the infallibility of the Scottish Criminal Record Office itself.
The trial took place in May 1999 at the High Court of Justiciary. And for anyone listening, you should know, the High Court is Scotland's supreme criminal court.
So the stakes could not have been higher?
It was a monumental confrontation. Yeah. You had the Scottish forensic establishment on one side and this lone police officer on the other. The jury listened to all the evidence, and in the end, they unanimously found Shirley McKie not guilty of perjury.
Unanimously?
Yes, which is an absolute legal rejection of the SCRO's core claim. It means the jury believed her, not the expert forensic evidence presented by the Scottish establishment.
What's so fascinating here, and what's really critical to understanding how the jury was able to reach that verdict, is the need for some kind of external objective proof. Because you can imagine the SCRO experts were very confident, very compelling in their testimony about their own internal standards.
Oh, I'm sure they were. And that is exactly why international intervention was so vital to this case. McKie's defense team brought in two highly respected U.S. fingerprint experts, Pat Wertheim and David Grieve.
And they weren't constrained by the internal politics or standards of the SCRO.
Not at all. They could apply their own rigorous, impartial analysis to the evidence.
So what was their definitive finding? What did they tell the court that directly countered the SCRO's experts?
Well, Wertheim and Grieve, they asserted definitively that the fingerprint found inside the Ross house, the supposed McKie print, was not her print. Their analysis, which they presented to the jury, actually demonstrated the error in the comparison.
So they didn't just say it was wrong, they showed why it was wrong.
Exactly, and this was a critical moment for forensic science itself. You see, the SCRO relied heavily on their own established process, their own institutional verification. But the U.S. experts showed that that process had failed. The jury saw this undeniable evidence, and they acted on it. They acquitted her.
So McKie's acquittal was the definitive legal validation of the SCRO's error. This wasn't just some clerical mistake anymore.
No, this was an error made under oath, directly implicating 4 forensic experts who had sworn in court that the print was hers.
And this is where the dots all connect back to the bigger, darker picture.
The original murder case.
Right. If the SCRO was so fundamentally wrong about Shirley McKie's print, a print they swore was a match, then their identification of the print on that tin box in David Asbury's home.
The linchpin of his conviction.
Exactly. That identification was immediately rendered deeply, deeply unreliable.
The proven fallibility meant the entire forensic foundation of the murder trial just collapsed.
The fallout was simply unavoidable at that point. McKie's success in proving her own innocence became the very mechanism for overturning a murder conviction.
David Asbury was subsequently freed from his life sentence. It is truly hard to overstate the profound implications here.
It really is.
Think about it. A single police officer's denial of being at a crime scene, a denial which led to her being fired and charged with a serious crime, ultimately proved that the entire institutional mechanism of forensic identification had failed. And that failure resulted in a miscarriage of justice that had imprisoned a man.
It's an astonishing reversal of fortunes, all stemming from one institution's refusal to admit a mistake.
And that sequence of events is what immediately broadened the scope of the issue, turning a personal prosecution into what became known nationally as the Shirley McKie Fingerprint scandal.
So McKie is acquitted. It's a massive victory, of course, but her career is in ruins, her reputation has been dragged through the mud, and her life has been completely turned upside down.
The fight for justice, then, had to shift from the criminal court to the civil arena.
What was her first attempt to seek some kind of redress after the acquittal?
Her initial action was a civil suit against her former employer's Strathclyde Police, and it focused specifically on the, let's say, highly questionable manner of her arrest.
But that didn't go well for her.
No, unfortunately, she lost that initial case in February 2003. And this loss wasn't just procedural. It had devastating financial consequences. It left her liable for a crippling £13,000 legal bill.
And £13,000 might not sound like a world-ending sum to everyone, but when you're unemployed, when you're recovering from a huge public scandal, and you're fighting the entire state apparatus.
It's crushing.
It is. The sources confirmed she was facing bankruptcy. We really need to pause and just think about the immense pressure she was under at this time. This is where you see individual tenacity meeting raw systemic power.
That financial jeopardy is really the hidden cost of fighting institutional denial, isn't it? The legal system, even when you're proven innocent, seems designed to be financially exhausting.
And if she had gone bankrupt at that point,
her fight would have been over. Her ability to continue, which was essential to exposing the deeper institutional errors, would have just ended right there.
But then something remarkable happened.
Yes, in a twist that's almost cinematic. In June 2004, an anonymous donor stepped in and paid the entire legal bill for her.
Wow. That anonymous intervention literally saved her from financial ruin.
It did. And critically, it allowed her to continue the legal fight for full accountability.
Which brings us to the second and much more ambitious civil action. This time she sued the Scottish executive, arguing that the failure wasn't just an accident, it was a systemic issue.
Precisely. And the basis of this second lawsuit was much more powerful and targeted. McKie alleged malicious prosecution.
Malicious prosecution.
Yes, caused by the dishonesty of the SCRO fingerprint experts. So this wasn't just about arguing a procedural error anymore. She was asserting that the experts knew their initial finding was wrong, or at the very least, recklessly inaccurate, and had doubled down to save face.
The case was scheduled to be heard in February 2006, but it never actually went to trial, did it? McKie never had to present her evidence in open court.
No, she didn't, because on the very morning the case was due to begin, the Scottish executive offered a settlement. McKie accepted £750,000 in a full and final settlement.
A huge sum.
It was. It provided her with significant financial compensation, finally acknowledging the immense harm that she had suffered.
But, and this is a big but, the executive insisted that the payment was made explicitly without admission of liability. Well, what does that legal phrase really mean in a case like this, especially given the size of the payment?
It's the institutional parachute. It's the escape hatch. While paying out £750,000 clearly signals that the government knew they were facing certain defeat and probably massive damages in court.
Right.
The without admission clause is designed to prevent that payment from being used as a legal precedent in any future challenges.
So it's a financial settlement for the suffering, but it's a legal shield for the institution.
Perfectly put. The state mitigates its financial losses while avoiding a formal judgment of wrongdoing that could lead to disciplinary action or, even criminal charges against the experts involved.
And this is where the philosophical and political battle really came into focus. It connects directly to the role of the Lord Advocate at the time, Colin Boyd.
Yes.
He had already offered a highly contentious legal opinion during an earlier phase of all this.
This is such a crucial piece of insight because it really reveals the mindset of institutional protection at the very, very top. The Lord Advocate is Scotland's chief public prosecutor and the highest law officer, a position of immense power. And Boyd had argued that Expert witnesses should always be granted immunity from prosecution.
Always.
Always, even if they gave false evidence.
Wait, even if they are proven to have lied or knowingly presented false evidence, that seems to fundamentally undermine the entire judicial search for truth.
It raises a profound ethical and systemic question, doesn't it? The argument, from the state's perspective, is often about protecting the mechanism of justice. The idea is that if experts fear prosecution for every single error, they might become reluctant to testify, and that could have a chilling effect on prosecutions.
But McKie's case demonstrated the other side of that coin perfectly.
It did. If experts are fully insulated from consequences, what incentive do they have to be absolutely meticulous? And what recourse does an individual have when their life is ruined by an institutional error born out of recklessness or even intentional misrepresentation?
It really suggests the priority was protecting the state's ability to prosecute cases efficiently.
Even at the cost of sacrificing individual integrity or allowing dishonesty to go completely unchecked? The public outcry after that settlement and after this legal argument came to light was just immense.
So that £750,000 payment was, for the public, basically proof of guilt.
Absolutely. The without admission of liability clause didn't fool anyone.
And the silence on actual accountability was deafening. So this moved the issue squarely into the political sphere.
It had to. Opposition parties in the Scottish Parliament immediately started demanding a full public inquiry.
And the Parliament's initial response was to refer the case to its Justice I committee in April 2006.
Now, this was a parliamentary investigation, not a full judicial inquiry, but it was a critical first step towards forcing some transparency. And the committee was serious. They heard testimony from over 30 witnesses.
These proceedings must have been highly anticipated. They forced all the key players to finally testify in public.
They were. McKie and her father, Ian, who had been this tireless, incredible campaigner for his daughter's justice, they appeared on May 23, 2006. They laid out the human cost, the personal cost, of the SCRO's mistake.
And then, just a week later, the 4 SCRO fingerprint officers who were at the heart of it all, Hugh McPherson, Fiona McBride, Anthony McKenna, and Charles Stewart, they had to testify.
That public juxtaposition was absolutely essential. The committee was, in effect, putting the state's experts on trial in the court of public opinion, forcing them to defend their work and their subsequent denials against the corroborated testimony of McKie and, of course, the findings of those international experts.
The public attention on these hearings really ensured that the institutional failures just couldn't be swept under the rug any longer.
No, they couldn't.
But during the committee's investigation, a major controversy erupted over transparency, didn't it?
It did. The Justice I Committee requested several internal reports concerning the SCRO's practices. There were 2 reports by John McLeod, another by Michael Pass, and the really critical one, the McKay report.
These were the internal examinations of the SCRO's own processes. The committee needed them to understand if the failure was down to individual negligence or a deeper systemic flaw.
Exactly. And the McKay report in particular was believed to contain some highly critical assessments of the office's competence and their verification procedures.
And once again, the institutional resistance came from the very top. Lord Advocate Colin Boyd refused to release that crucial McKay report.
He did. His argument was that releasing it would prejudice any potential future criminal action against the officers involved. He cited, quote, fundamental principles of our democracy, including the presumption of innocence.
Which, while legally sound in a vacuum,
in the context of a public that was already convinced of an institutional cover-up, this refusal was widely seen as political protectionism. Critics argue the government was just trying to bury evidence that would embarrass the SCRO.
But the government's attempt to keep it secret was completely undermined.
It was. A 56-page leaked copy of the McKay report was published by the BBC. This leak must have been a political earthquake.
Oh, absolutely devastating for the government. The leak proved they had something significant to hide.
It exposed the internal findings, which reportedly did criticize the SCRO's working practices and their standards. And the leak itself suggests a deep internal lack of faith. Someone within the system clearly felt that the need for public transparency outweighed the Lord Advocate's desire for secrecy.
It essentially forced the government's hand.
It did. It forced them to acknowledge the underlying truths the report contained.
And in the meantime, the 4 SCR staff involved were facing their own internal institutional pressure, even before the parliamentary inquiry had concluded.
Yes. In September 2006, the 4 fingerprint officers were reportedly offered a deal by the SCRO. Resign or take early retirement.
Classic institutional damage control.
Absolutely. It allows the organization to remove the employees at the center of the controversy without having to fire them or admit any specific misconduct, which in turn minimizes any further legal exposure.
But even that attempt at a quiet removal was met with some resistance.
It was. Their union, Unison, criticized the timing of the offer. They argued the officers were being harassed before the parliamentary report was even published.
It highlights a really tricky dynamic, doesn't it?
It does. The institutional need to restore public confidence by removing the implicated staff runs directly into the legal rights of those employees who are, technically still presumed innocent of any criminal misconduct.
And then the Justice I Committee finally published its report.
A substantial one, too. A 230-page report on February 15, 2007. And while this closed the parliamentary investigation, the need for a deeper, more powerful judicial inquiry was now greater than ever.
So, following the publication of that report and the £750,000 compensation payment, the public campaign for a full judicial inquiry just intensified.
It did. The issue had really expanded beyond Shirley McKie's personal story. It had become a symbol for the broader failings of the entire Scottish criminal justice system.
And the campaign gained significant political weight when Ian McKie, Shirley's father, partnered with Dr. Jim Swire.
Dr. Swire, the father of one of the victims of the Lockerbie bombing.
Yes. They launched a joint campaign in March 2006, and they were highlighting that the forensic failures seen in McKie's case were systemic issues that could have affected multiple high-profile Scottish legal proceedings.
Dr. Swire's statement at the time just perfectly captured the national gravity of this issue. He argued that these failures were undermining global trust in the nation's legal process.
What did he say?
He stated, "The reputation of our country and its criminal justice system will depend upon how these cases are sorted out."
By linking the McKie scandal to the reputation of Scotland itself, he successfully framed this failure not as just a police error, but as a national crisis of confidence.
Exactly, and one that demanded a full, independent judicial response.
The government, however, initially resisted, didn't they? They must have feared the immense cost and the political fallout of a truly independent inquiry, one that would have the power to compel evidence and testimony.
They did resist, but the pressure just became unbearable, and McKie's family signaled the end of their long personal fight on a very symbolic date. January 9, 2007, a decade to the day after the Marion Ross murder investigation began.
Wow.
Ian McKie made it very clear that they had done their part.
He delivered a powerful message to the politicians, didn't he? I remember him essentially saying, "We have given 10 years of our lives to this and we are not giving any more."
It is the politicians' job now to do something about it. It is not our role to fight for justice. It is their role.
That statement just left the ball squarely in the government's court. It forced accountability.
And the government finally capitulated. In March of 2008, they announced the launch of a major public inquiry, which became known as the Fingerprint Inquiry.
And to ensure its impartiality, it was led by Sir Anthony Campbell, a highly respected former judge from Northern Ireland.
Which signaled a very serious commitment to a root and branch examination. This wasn't going to be just political window dressing.
The inquiry formally opened in October 2008, with public proceedings getting underway in Glasgow in June of 2009. These proceedings were exhaustive, I understand.
Incredibly so. They involved senior counsel making public presentations of all the evidence that had been collected over the past decade.
And the culmination of this incredibly long and expensive process was the publication of Sir Anthony Campbell's comprehensive report on December 14th, 2011.
And that final, authoritative document laid out the entire history of the SCRO's failure, the subsequent institutional denial, and all the necessary recommendations for systemic reform. The whole point was to ensure that this type of catastrophic error, and the cover-up that followed, would ideally never be repeated.
It's important to recognize, though, that the McKie case, while it was uniquely painful for the family involved, wasn't some isolated event globally. The source material we have references parallel cases demonstrating a much wider crisis of confidence in forensic identification.
That global context is absolutely crucial. The reliance on human judgment in fingerprint identification was starting to show cracks worldwide. The sources mentioned the Brandon Mayfield case.
An American lawyer falsely implicated in the 2004 Madrid train bombings.
Exactly, based on a faulty fingerprint match made by the FBI. This demonstrated that even the most sophisticated forensic agencies could make critical, life-altering errors.
And the sources also point to the New York State Police Troop C scandal, which involved the outright fabrication of crime scene fingerprints.
These global examples all underscored a critical lesson. When forensic agencies become insular and they rely too heavily on their own internal standards, like the outdated 16-point standard that was used historically, without rigorous external validation,
The margin for error just increases.
it increases dramatically, as does the potential for denial, and even in some cases, malicious intent. The McKie case, along with the Mayfield case, helped to drive that necessary global shift towards more standardized, verifiable, and open methods of forensic comparison.
Methods that rely less on subjective expert judgment and more on objective, holistic assessment.
Precise.
This entire saga, starting with a murder, evolving into a miscarriage of justice against a police officer, and ending with a judicial inquiry, it had a profound cultural impact in Scotland. It proved that public feeling on this ran very, very deep.
And when official channels fail to deliver justice, art often steps in to capture the collective mood. The sense of shared injustice was powerfully articulated by the Scottish folk singer and poet Michael Murrah. He wrote a protest song about the case.
And the lyrics of that song powerfully captured the feeling that Shirley McKie's fight represented a much larger battle between the individual and the state.
The lines that really resonate the most are, "I am Shirley McKie. She is me and I am she. You are too, Shirley is you. We are she because Shirley is we."
That sentiment really cemented her status as a symbol of integrity betrayed by institutional arrogance.
It did. And the story was further immortalized with the publication of the book Shirley McKie. The Price of Innocence in 2007, ensuring the scandal remains a crucial landmark in the history of Scottish justice.
So after this comprehensive exploration of the material, the ultimate synthesis is pretty clear. A single denied print challenged the established order. It destroyed a career, it forced a murder conviction to be overturned, and it necessitated a massive, decade-long governmental investigation into the very standards of forensic science and public accountability in Scotland.
It's an incredible testament to the power of one person maintaining her truth against just overwhelming institutional pressure.
The central lesson, I think, for anyone interested in how legal systems actually function is that the pursuit of justice often requires immense personal and financial sacrifice when you're challenging institutional power.
And McKie was successful because she had that tenacity, and critically, she had the support of international experts who were willing to stand up and counter the state's forensic testimony.
Which leads us directly to a final profound question based on the facts we've explored today. We noted earlier that Shirley McKie lost her initial civil suit and was facing bankruptcy because of a crippling £13,000 legal bill. If that anonymous donor had not stepped forward in June 2004 to cover that initial cost, she would have been financially ruined. She would have been likely unable to pursue the successful civil action that eventually secured the £750,000 settlement.
A settlement which, because of its sheer size, forced the government's hand and triggered the full, ultimately revealing public inquiry.
So the question for you to consider is this. Given that the exposure of such a grievous systemic failure, one that overturned a wrongful murder conviction and forced nationwide judicial reform, depended entirely on the serendipitous intervention of an anonymous private citizen, what does this tell us about the structural flaws in our legal systems?
Should the achievement of justice and the exposure of institutional dishonesty ever rely on chance and private funding? Or should the legal mechanism itself be robust enough to guarantee the protection and the financial viability of the person telling the truth?
Thanks for listening.